In this lecture, I'm going to briefly talk about inchoate offenses with a particular focus on the general attempts provision contained in section 24 of the Criminal Code. So here is section 24. As you can see, it says, everyone who, having an intent to commit an offense, does or omits to do anything for the purpose of carrying out the intention, is guilty of an attempt to commit the offense, whether or not it was possible under the circumstances to commit the offense. Now, as the language of section 24 sub 1 suggests, our focus here in determining whether someone has committed an offense under section 24 sub 1 is very much on the intentions of the actor. Of course, if you'd engaged in the completed offense, whatever it was, then we just charge you under that. If we're relying upon section 24 sub 1 at all, it's because you purported to do something or omit to do something you had a legal duty to do for the purposes of committing that other offense, whatever it was. But for the fact that you engaged in that act or omission for that purpose, with that intention, the conduct might be perfectly lawful in and of itself. What makes your conduct criminal, what makes it an attempt under section 24 sub 1 is your intention. Why did you do the thing that you did? With that in mind, we are perhaps somewhat unusually going to focus at the outset not on the actus reus of the offense, but on the mens rea. What mental states must the Crown prove in order to show that the defendant attempted to commit a criminal act? Well, first, the Crown must establish an intention to commit the completed offense, whatever it was. And further, there must be an intention to engage in the act or omission in question for the purpose of carrying out that offense. It follows from this that even if the completed offense has a mens rea requirement of something less than intention, there must be an intention in order to establish an attempt under section 24 sub 1. So even though one can commit murder without having an intention to kill, one must have an intention to kill in order to be convicted of attempted murder. And as that example suggests, to the extent that there are any consequences built into the actus reus of the completed offense, these consequences must be intended. What about the actus reus for 24 sub 1? Well, again, as the language of that provision suggests, one can engage in an attempt by performing, in principle, any act or omission under the sun. But there's a catch. One must move beyond preparatory steps by way of carrying out the offense into perpetration of the offense, which is to say, the act or omission in question must not be too remote. Now, there's some fuzzy language here, isn't there? What does it mean to move beyond preparation into perpetration? What are we talking about when we talk about an act or an omission being too remote? How remote is too remote? In Deutsch, Mr. Justice Ledane refused to adopt any simple, or at least simplistic, test for determining whether we moved beyond preparation into perpetration. He insisted that the test must be qualitative, not quantitative. We can't determine whether someone has moved beyond preparation into perpetration simply by counting the number of steps taken, as it were, towards completing the offense, or counting the number of steps that might remain. We must instead focus on the nature and quality of the defendant's conduct in relation to the completed offense. Now, in Deutsch, the defendant was accused of attempted procurement of illicit sexual intercourse. He was interviewing candidates for a secretarial position, advising them that the job would involve having sex with clients. In the end, though, he doesn't hire anyone. So the question is, does his conduct move beyond preparation into perpetration? According to the Supreme Court, it did. So long as there was the intention to carry out the offense, holding out financial rewards to candidates, all the while explaining their duties should they get the job. The defendant, the court concluded, had sufficient proximity to the wrong targeted by the completed offense. It's also worth commenting on this last little part of the sentence here in section 24 sub 1, whether or not it was possible under the circumstances to commit the offense. Now, what does that mean? Now, to make sense of that final clause in section 24 sub 1, we need to return to the point with which I started, that the provision is very much focused on the intentions of the defendant. The conducting that in which the defendant actually engaged, the act or omission in question, may, as I said earlier, be entirely non-blameworthy in and of itself. Certainly may not be a crime in and of itself. We are attributing blame to the defendant for engaging in that conduct, not because of the conduct itself, but because of the defendant's intentions when he or she engaged in that conduct. It is the intention to engage in that conduct for the purpose of carrying out a criminal offense. That's what justifies the stigma and punishment heaped upon that defendant. Well, with that in mind, why would it matter that, as a matter of brute fact, the act or omission in which the defendant engaged wasn't actually capable of advancing the criminal offense that the defendant was trying to commit? After all, whether or not it was actually impossible, the defendant need not have known that. Indeed, plainly, he didn't know that. He thought he was taking steps to commit a criminal offense. As it turns out, he was thwarted by reality. But in terms of having the blameworthy state of mind, well, it's still there. Now, there are lots of different ways in which one can fail to commit a criminal offense on the basis of impossibility. First, there may be inadequate means. Let's say Jane tries to kill Bill, but doesn't use enough poison. Quite simply, the amount of poison used is incapable of causing death. Take another example. Let's say Bill tries to break into Jane's house, but lacks the tools necessary to do so. Now, there's no question that in either of these scenarios, involving what we might regard as inadequate means, that that sort of impossible attempt will absolutely be caught by section 24 sub 1. There's a second kind of impossibility here. Perhaps it's physically impossible to commit the offense that the defendant intends to commit through any means. So if we imagine that Jane tries to kill Bill, but wah, wah, Bill is already dead. Well, can Jane be convicted for attempted murder? Absolutely. There is, however, a more complicated scenario, one which has been left somewhat open. What if you attempt to smuggle icing sugar into the country, believing that's a crime, when it actually isn't? Does that count as an impossible attempt? On one hand, we might say, well, why not? No, it's not actually a crime, but you thought it was. And you took steps. You moved beyond preparation to perpetration. So you had, in a sense, the blameworthy state of mind. You intended to commit a criminal offense. You took the necessary steps. So there's a sense in which that sort of scenario we might think ought to be caught. And yet, I think probably the better view is no. That in the end, you must be attempting to commit a crime. And whether or not something is a crime is not just a matter of what you happen to believe is a crime. It's either a crime or it's not. And if it's not, then your intention to engage in it, however blameworthy it might be, seems to me almost certainly isn't caught by section 24 sub 1. Read on its face, section 24 sub 1 leaves open the possibility that one can be convicted of attempting to commit any offense in the criminal code. But the Supreme Court in Dery made it clear that that's not the case. Now, the facts in Dery are somewhat amusing. The long and the short of it is that the defendant had attempted to convince someone to agree to embark on a criminal scheme to steal beer. And the question then is whether or not the defendant, there wasn't a conspiracy, but can he be convicted of attempted conspiracy? The Supreme Court concludes no. There is no such offense known to Canadian law as attempted conspiracy. Now, why not? After all, as I say, section 24 sub 1 doesn't straightforwardly impose any limits on what offenses one can attempt to commit. So why say that there can't be such a thing as attempted conspiracy? Well, the court emphasizes that there can't be such a thing as an attempt at an attempt. You see, the offense of conspiracy is what we might describe as itself an inchoate offense, or indeed possibly even a preparatory offense. After all, what is a conspiracy? A conspiracy is a number of people getting together and essentially agreeing to carry out an offense. So, what does it mean to say that you can be convicted of attempting to conspire? Well, it means that you can be convicted for attempting to start up a conversation with another for the purposes of carrying out some further offense. And what's bothering the court here is how far back in the chain of events we are, how remote we are now from the completed offense. And to the Supreme Court, reading the offense, or reading section 24 sub 1 in such a way that one can attempt to commit any offense in the code, including conspiracy, just expands liability much too far, certainly further than the court's prepared to infer Parliament intended. To reach the conclusion that Parliament intended to make attempted conspiracy a criminal offense, the court basically says we're going to need clearer language to that effect. And for the sake of completeness, it's worth saying that conspiracy is far from the only offense in the code that targets what we might regard as merely preparatory conduct. After all, if we think about an offense like the offense of child luring, now, as the court in Morrison, as the Ontario Court of Appeal in Carbone emphasized, there may be nothing intrinsically problematic about the communications that one is having on the internet. What makes it criminal is the intentions behind the communication. If we're talking about communications that are, for example, very early in the grooming process, well, there may be no, as I say, intrinsically blameworthy content to those conversations. It may be, to all appearances, quite innocent. However, the defendant's intentions to, again, lure the child in, lure the person he believes is a young person in, so that that person may be gradually groomed for sexual activity, perhaps a much later stage. That intention makes the conduct criminal. And one suspects that, based on the reasoning in Dery, that it might be just as problematic to speak of attempted child luring. But that's a question that has not been resolved as yet. So that's all for today. This was just intended to be a brief discussion of some of the more salient issues in the law of inchoate offenses, and again with a focus on section 24 sub 1 of the code. See you next time.